He has a $10 bond on that case. Case People versus Andrew White.
Edward Lucas on behalf of Andrew White.
Your name, sir?
Andrew White?
I have before me a plea form. Is that what we're doing today?
Yeah.
Yes, Your Honor.
Plea form indicates that the defendant would be pleading guilt or no contest to the charge of larceny 200 to 1,000. The 1 year offense upon the successful plea to that charge, count one would be dismissed. The issue of restitution is preserved and there is no delayed or deferred. That's the court's full understanding of the agreement.
That's correct, Your Honor.
All right, may I have him sworn?
Right hand, you solemnly swear and affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name.
Andrew White?
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of larceny 200 to 1,000.
Yeah.
Correct?
Yes, that is right.
All right, that's a misdemeanor punishable up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, I do.
All right. You understand what a no contest plea is?
Yes, I do.
All right. 2 things I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, I do.
All right. You understand, sir, also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Yes, I do.
All right. Basis for the no contest plea?
Civil liability.
All right. So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, I do.
All right. You signed an advice of rights form?
Yes, I did.
Any question regarding those rights?
No?
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yeah?
Are you on probation or parole?
No?
Has anybody promised you anything other than
Yeah.
what's been stated here today to get you to plead?
No, they haven't.
Anybody threaten you or force you?
No?
You're doing this voluntarily
Yes, I am.
of your own free will?
Yes, I'm on.
And because you believe, well, I won't ask that. All right. Court has been provided Ann Arbor Police Department report for their case number 23-31327. Any objection to the court having reviewed that report?
No objection.
All right, court, based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
July 19th at 10 a.m. before Judge Perry.
July 19th, 2024. What time? 10 a.m. before Judge Perry.
And Your Honor, if I could address bond just briefly.
Okay.
Based on the plea today, the felony being dismissed, he has another companion case that he took a plea in the 15th district to a similar offense. He's got a $10 cash bond in that case. This case is set as a $10,000 cash or surety bond.
He has a $10 bond on that case?
It was 10%. Okay, well, I got the 100.
I'd be asking,
What is it? Is it $10, 10%?
It was 110%.
Or it's 110%?
I thought it was just a $10 cash bond, but it looks like $100.
No.
Dollars.
Just $100. It's $100, so 10%.
Oh, okay.
So based on this, I'm asking for a similar bond in this case. They both are
What is it?
right now. $100.
No 10%, just $100. Is that what his bond is?
Yeah.
That's what I heard. Any,
Just typically I would sit and let the misdemeanor plea happen. However, the defendant has no bond for Birmingham Police Department. It says fraud and then in parentheses, the letter F. I don't know if that stands for felony or fraud. I don't know. So I don't know any of the details about the case. I just know that his bond is denied in whatever Birmingham has for him. So perhaps we could keep him here rather than keep him before his sentencing date.
you didn't know about that.
I was actually looking it up this morning. I was informed of that this morning.
Got it. I'll deny at this time his motion for bond reduction. I get what you're saying. I'll deny it so that he's here. Bond will continue. Thank you. This is, he's ending in 1787. He is bound over on counts 1 and 2. Mr. Meyer.
Your Honor, with respect to the one ending in 5203 and 0270, we acknowledge receipt of the information, waive its reading today, and ask that Mr. Flory be permitted to stand mute.
In case 1787, we waive its formal reading of the information, acknowledge receipt of it, and ask the court to allow Mr. Fleury to stand mute.
Brendan, having waived formal reading, standing mute, the court will enter a not guilty plea. Pre-trial in these matters will be set for
July 10th at 1:30 before Judge Conlon.
July 10th, 2024, 1:30, Judge Conlon.
Thank you, Your Honor.
Those matters, bond will continue. On the remaining matter, the assault with intent to do great bodily harm, strangulation, and domestic violence. All discovery on that matter is complete.
Yes, Your Honor.
Would the people have their witnesses available to second? Preliminary examination in person, July 2nd, 2024, 9 a.m. That is before Judge Perry. Found on that matter and all the matters will continue.
Thank you. That one's on the table.
Court calls the case, People versus Casey Boyd. Yes, as soon as they're ready.
Maria Wasinski seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Senior Assistant Public Defender Joy Gaines and on behalf of
Okay, permission to practice is granted.
Thank you. And Your Honor, please
Your
state your
name,
name for the record.
Casey Boyd.
Thank you.
Thank you, Your Honor.
We haven't been able to get into contact with Mr. Boyd, so we would
He's
be
right
asking
there.
for a brief adjournment.
Preliminary examination, July 11th, 2024, 9 a.m. Bond will continue. Keep in contact with your attorneys. All right. Thank you. Court does call the case, People versus Sean Carlson. Okay, sorry.
Maria Wasinski on behalf of Mr. Carlson. Please state your name for the record.
Sean Carlson.
All right, what are we doing?
Your Honor, we would be also asking for a 2 to 3 week adjournment for discussions with the people about an offer.
Probable cause conference, July 11th, 2024, 9 a.m. Bond continued. Court does call the case of the People versus Eddie Gardner. Court does call the case, People versus Carrie Dillard.
On behalf of Mr. Dillard, would you state your name for the record once you're at the podium?
Gary Dillard.
Thank you.
Judge, I'm asking that on both, I'm representing on both matters. We're asking that this be set for exam.
Discovery is complete on both matters.
I believe so.
People have their witnesses available on both cases, July 2nd.
Judge, may I address bond briefly?
Okay.
Mr. Dillard is the sole provider of, he's got 4 kids, ages 2 to 13. he would like to get back to his job at construction. He could live with his mother in Belleville. He will have no contact with the victim, who is the mother of the four kids. That being said, Your Honor, we're asking that the court reduce the $25,000 bond, which I believe set in both cases substantially. We'd ask that PR bond released if tether, if need be.
Judge, these are cases that happened within a day from each other on June 9th, and June 10th, the victim. The 13-year-old child was present. She was the one that actually called 911 in this case. There are obviously serious allegations involving a weapon that he brandished during the DV situation. So I believe bond is reasonable. We had originally asked for $100,000 bond each case. $25,000 bond was granted. So we have to keep the same.
Judge, just very briefly, it's almost the same incident, Your Honor. Again, I'm not minimizing two charges, but it just carried over to the next day. And I believe the weapon was licensed, licensed to the victim. All that being said, Judge, we're asking that he be able to support his kids.
Defendant's motion for bond reduction is denied. Bond will continue. Preliminary examination will be set July 2nd, 2024, 9 a.m. before Judge
What do you,
Washington.
This from the heart, this.
Judge, I know you've made your decision, but my client is asking me to ask you again. He promises not to have any contact with the victim.
But I'll be,
If whatever you're going to say, what are you going to say?
Judge, I know you don't know me, and the situation at hand, I was gonna go backwards. I made a lot of strides through here. Not be in this position. I worked real hard not to even be coming back to the situation. If you can just grant me house arrest, other something, I'll be in jail. It's like
Here's what I know, and you're right, I don't know you. Here's what I know. The allegations that have come before the court is that there is a domestic violence situation which precipitated itself or continued into another day and involved a firearm. That's what I know.
You're not.
It didn't. It never involved.
Judge, for what it's worth, a firearm was found. There was no evidence that a firearm was pointed at anybody. It's just that a firearm was
My
found,
understanding
which,
is it was brandished.
Oh,
Judge, I don't believe that at all.
it was found.
It was simply found that the weapon was licensed to the victim.
My ruling stays.
I'm sorry?
My ruling stays.
Thanks, Judge.
Oh, you want me to
No.
change it?
Oh,
I will do more than that if you want me to.
Thank you, Judge. We appreciate it.
Yes, I'm serious, dead serious. They're in the three matters that are two charges of assaulting, resisting, or obstructing an officer. A charge of delivery, manufacture of a controlled substance. Basically, this is in case ending in 270. And possession of meth, ecstasy, and operating while intoxicated, as well as the case that ending in 1787 of delivery or manufacture of a controlled substance and delivery or manufacture of methamphetamines. You're wishing to waive your right to have a preliminary examination, sir?
yes, Ron.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Ron.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution of these matters.
Yes, Ron.
All right. On those cases, people also waive their right.
Yes, Your Honor.
In case ending in 5103, defendant bound over on counts 1 and 2. In the case ending in 270, he's bound over on counts 1 through 3 with 4 foul. In the case ending in 1787, he is bound over on counts 1 and 2. Mr. Meyer.
Your Honor, with respect to the one ending in 5203 and 0270, we acknowledge receipt of the information, waive its reading today, and ask that Mr. Flory be permitted to stand mute.
In case 1787, we waive its formal reading of the information, acknowledge receipt of it, and ask the court to allow Mr. Fleury to stand mute.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial in these matters will be set for
July 10th at 1:30 before Judge Conlon.
July 10th, 2024, 1:30, Judge Conlon.
Thank you, Your Honor.
Those matters, bond will continue.
And good morning again, Your Honor. Christina
They
Constantine.
come from. I didn't see.
I was hiding back there.
Yeah, I didn't see you. So he just appeared. Anyway, your name, sir?
Eddie Garden.
Thank you. What are we doing?
Your Honor, at this time, it's my understanding that discovery is complete and we would be requesting that this matter be scheduled for preliminary examination.
Discovery is complete in my matter also, Your Honor. They are separate matters, but we would ask that they be set for the same day.
People have their witnesses available. Oh, you can't. Second.
No, I'm sorry, Judge.
Your Honor, Ms. Convertino and I are both available. I'm sorry, I knew her as Miss Joseph, and I said still when I try to call her Judge.
Okay,
We're both available on the 9th.
so. No.
At least you have water now, Judge. You know.
Yeah. All the
You sure
simple.
it's just water?
Wow, really? Wow. Goldstein said that. It is water. And now we're gonna make him drink. Preliminary examination in person. Wow, David. July 9th, 2024, 9 a.m. before Judge Burke. Thank goodness that was not me. For David's sake.
And my client's sake.
No, he would have been fine. You would have had problems. All right, bond will continue.
Thank you, Judge.
There is one
Okay.
issue.
Yes, sir.
Detective Luke obtained a search warrant for the defendant's DNA. They attempted to effectuate that in the jail. The defendant refused to comply and would not let the detectives take the buckle swab pursuant to that search warrant. They are present here today. I'd ask that either the court could order him or it could be effectuated up here. The best way to handle that, but they were running into issues with the inability to obtain his DNA.
Judge, I don't think the court needs to order it at that time. At this time, I've spoken with my client about it. He will provide his sample today pursuant to the search warrant.
He'll do it right now. You guys can go back there. You can do it. Let me know before I continue to respond on this case or have the 7th or the 9th as the day. I want to make sure that that has occurred because otherwise I'll start moving things around and readjust the bond in this matter. You can go back and then once Court does call the case of the people versus Eddie Gardner.
And good morning again, Your Honor. Christina Costantino appearing on behalf of Eddie Gardner.
David I. Goldstein appearing on behalf of the defendant in file that ends 0635. Your Honor.
Where'd Goldstein come from? I didn't see.
I was hiding back there.
Yeah, I didn't see you. So he just appeared. Anyway, your name, sir?
Eddie Gardner.
Thank you. What are we doing?
Your Honor, at this time, it's my understanding that discovery is complete and we would be requesting that this matter be scheduled for preliminary examination.
Discovery is complete in my matter also, Your Honor. They are separate matters, but we would ask that they be set for the same day.
People have their witnesses available? Oh, you can't. Second.
No, I'm sorry, Judge.
Your Honor, we're, Ms. Convertino and I are both available. I'm sorry, I knew her as Miss Joseph, and I said still, but I tried to call her Judge.
Okay,
We're both available on the 9th.
so. No.
At least you have water now, Judge. You know.
Yeah. All the
You sure
simple.
it's just water?
Wow, really? Wow. Goldstein said that. It is water. And now we're gonna make him drink. Preliminary examination in person. Wow, David. July 9th, 2024, 9 a.m. before Judge Burke.
Yeah.
Thank goodness that was not me. For David's sake.
And my client's sake.
No, he would have been fine. You would have had problems. All right, bond will continue.
Thank you, Judge.
There is one
Okay.
issue.
Yes, sir.
Detective Luke obtained a search warrant for the defendant's DNA. They attempted to effectuate that in the jail. The defendant refused to comply and would not let the detectives take a buccal swab pursuant to that search warrant. They are present here today. I'd ask that either the court could order him or it could be effectuated up here. And the best way to handle that, but they were running into issues with the inability to obtain his DNA.
Judge, I don't think the court needs to order it at that time. At this time, I've spoken with my client about it. He will provide his sample today pursuant to the search warrant.
He'll do it right now. You guys can go back there. You can do it. Let me know before I continue to respond on this case or have the 7th or the 9th as the day. I want to make sure that that has occurred because otherwise I'll start moving things around and readjust the bond in this matter. You can go back and then once you guys get it, let me know. Please. Court does call the case People versus Dina Leverhagen.
Andrew Childers appearing on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Levenhagen. Ms. Levenhagen, can you state your name for the record, please?
Nina Levenhagen.
Thank you.
Your Honor, we are asking for an adjournment. We'd ask for a lengthy one if possible. We are working on getting some documentation from the prison, which is taking a little bit longer than we expected.
Hearing no objection, July 25th, 2024, 9 a.m. bound continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case People versus Tyresa Scott.
Assistant Public Defender Natalie Pay on behalf of Ms. Scott. Ms. Scott, can you please state your name for the record?
Tyresa Scott.
Thank you.
Thank you, Your Honor. At this time, it is my client's desire to set this matter for preliminary exam.
All right, all discovery is complete.
Yes, Your Honor.
Just so the court is aware, an offer has been extended that if the defendant were to waive her preliminary exam, we would not add a habitual offender upon bind over. It appears that that is being rejected today. That offer will close if it is being set for exam.
That was our understanding, Your Honor, and I have relayed that offer to my client, and she wishes to reject that offer and set this for preliminary exam at this time.
She's in the women's facility.
Yeah.
Preliminary examination in person will be set July 2nd, 2024, 9 a.m. And that is before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. Calls cases People versus Ezra Fleury. They're not one. They're not up. Hold on. Pass those briefly. They're coming right now. Okay. Ezra Fleury.
Good morning, Your Honor. Andrew Meyer on behalf of Ezra Flurry in matters ending in 0270, 5102, and 5103.
Good morning, Your Honor. Marcia Baker on behalf of Mr. Fleury and case ending 178.
Ezra Flurry.
It's examination waiver on all of this.
No, Your Honor, it's a waiver on 3. We are asking that the matter ending in 5102 be set for an exam.
So just so the court knows, there was an offer of global resolution on all 4 of these cases. If he does not waive up on all of them, that offer is not in play.
We discussed the offer with him. This is what he wishes to do today.
The offer was in page 24F5, 5102, complete count 1 and dismiss count 24F5, 5103, complete count 1 and dismiss count 2. 24F1, 0270, plead to counts 1, 3, and 4, dismiss count 2, dismissing 2, 3, F2, 1718 outright with the sentencing agreement to 4 to 7 years.
He's rejecting that offer.
We discussed it and what he wishes to do today, waive on the 3 and
So he's
that's the other one.
rejecting the offer.
Yes, Your Honor.
Your Honor, here.
Good morning, sir.
Assistant Public Defender Jay Bellinger on behalf of Mr. Keith. Your Honor, we have provided the court with a waiver this morning.
All right. And Mr. Key, you're going to waive your right to have a preliminary examination in this matter?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Thank you. Your Honor, as to that, we acknowledge receipts were made. We have a formal reading at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pre-trial does call the case, people, versus Jason Allen.
Andrew Children's defendant on behalf of the people.
All 6 cases.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Allen.
Good morning, Roger Kilwell, Your Honor. I'm on several matters. 24F1, 0693.
This is on the remaining matters.
Yes. All right. What are we doing?
Your Honor, we did propose and request a global resolution. Mr. Allen does have some other cases. We submitted a mitigation letter to Mr. Childers and the other prosecutors on his other matters, and we're hoping to resolve this. So we'd ask for an adjournment for them to have an opportunity to consider.
Same with you, Mr. Cole.
Oh, yes, I'm sorry.
All right. How much time would you need to do that?
I'll put this back to Ms. Gaines and Mr. Kilwell. My understanding is that Mr. Allen is seeking admittance into a veteran treatment support program. My decision would kind of be connected to whether or not that is granted to Mr. Allen. So how long do you expect to have an answer?
Your Honor, if we'll submit that paperwork to you today and maybe 3 weeks for them to do an evaluation.
Is it this Veterans Court here?
This one here.
Probable cause conference, July 18th, 2024, 9 a.m. on all matters. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Omar Anderson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Anderson, who stands to my right. Please state your name for the record, sir.
Omar Anderson. Thank you.
Thank you, Your Honor. As to the PCC, we wish to set this matter for exam.
All discovery complete.
To our knowledge, Your Honor.
People have their witnesses available. The second preliminary examination in person will be set July 2nd, 2024, 9 a.m. before Judge Perry. Bond continue.
Thank you, Your Honor. May I briefly address bond?
Briefly.
Thank you, Your Honor. As Your Honor is aware, Mr. Anderson was remanded last week at his probable cause conference for jail calls he made after his arraignment to the complaining witness. Our request at this time is for the court to consider setting bond at what it was previously. Mr. Anderson would stay in Pontiac with his mother. The complaining witness does not live there. She resides in Northville, to my understanding. Since his remand last week and for the prior 2 weeks that he was out prior to his remand, he had not had any contact with the complaining witness in this matter or no other bond violations, to my understanding. This is his only open criminal case, and he does have work at E&E Manufacturing in Plymouth, Michigan as a transfer press operator. He has been there for 2 years. As of last week, he still had that position and believes that he would be able to return to work if released from the jail today. Our request at this time is for the court to consider setting bond as previously set and allowing him to be released today.
I don't need a response from the people. Motion for bond reductions denied, bond ruling made, revoked. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus John Garrett.
Good morning. For the record, Erica Julian appearing on behalf of John Garrett, who I believe is joining us by Zoom.
Garrett, can you unmute and state your name, please?
John Garrett.
Thank you.
Good morning, Your Honor. This is a date for a PCC. I know that he had 2 other felony cases where he was recently arraigned and that those have, I don't think it's been updated in the system, but I'm sure that those are also scheduled now for PCC. I'm asking for an adjournment of this one so we can work things out with what those other 2 are.
When are the other 2 set? Do you know?
I saw, the last thing I could see was that there were warrant recalls on the 18th, which was 2 days ago. And then obviously yesterday was Juneteenth, so the court was closed. I couldn't get an update.
Probable cause conference in this case will be adjourned then to June 27, 2024, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Court calls the case, people versus Zachary DeGeorge.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. DeGeorge. State your name for the record, please.
Zachary Michael DeGeorge.
Hey, what are we doing?
Honor, this matter has been adjourned so that Mr. DeGeorge could be screened for the mental health court. I have had a response from Paul Graveline. It's indicated that Joe Royal has been scheduled to speak with my client. Has Mr. Royal seen you?
Not yet.
Okay. So we expect that interview to take place very shortly. So we'd ask for just 2 weeks to be able.
I think 2 weeks to do it.
Absolutely, that should be enough.
All right. July 11th, 2024, 9 a.m. Bond continue. Okay. What's the temperature? 77 right now. It's going to get to 90, right? And you would admit I'm a human being. I am. And that a human being needs water on a hot day. No, I'm just saying, no, if any of that is untrue, just let me know. Okay. All right. So if everybody knows if I fall out, it's because nobody gave me water. No, not talking to you. What? It is. Doesn't matter. Still needs water. You didn't care either. Never mind. Never mind. No, I'm just gonna sit up here and just melt. I'll be fine. I'll do what I can. Court calls the case, people versus Jeffrey Shue. No, it's not there. There's no water. There's nothing. No moisture up here whatsoever. Except in the air.
Good morning, Your Honor.
Oh, boy. And then she shows up. I have no water. Constantino's here.
I would have brought you water.
I know you would have. I don't know about my staff. Go ahead.
Christina Constantino on behalf of Jeffrey Shue. Mr. Shue, can you state your name for the record?
Jeffrey Shue. Thank you.
And
two, Alan. Two.
You'll be extra hydrated. Good. Extra hydrated. Just the date and time set for a PCC. We are asking at this time to have this matter set for a preliminary examination. It's my understanding that discovery is complete.
All right. Would people have their witnesses available on the 2nd?
Judge, is it at all possible to do the following week?
Now that I have water, maybe.
Thank God for the water.
Preliminary examination, July 9th, 2024, 9 a.m. That's in person before me.
Wonderful.
Oh, joy.
Let's continue. I'll bring an extra water.
Yeah, okay. Thank you.
Thank you.
Thank you, Your Honor. Thank you, sir.